And I'm going to hand straight over now to our next panel, which they're all just rearing to go, so I can barely stop them from unmuting themselves. So I'm going to hand over to my colleague, Scott Walker, who's going to chair this next session with our terrific and esteemed group of commentators who are going to be taking a deep dive into some of these issues. So over to you, Scott.
Thank you, Melissa, and thank you, President Croucher, for a really stimulating and motivating keynote. As Melissa has already said, my name is Scott Walker, and I am a research fellow of the Castan Centre for Human Rights Law. I want to begin by acknowledging the Wurundjeri people of the Kulin Nation, on whose land I'm joining from today, and pay my respects to the elders past and present. As Melissa has already indicated, our next panel discussion is on a Human Rights Act for Australia. And we're excited to be able to welcome 4 excellent speakers to discuss this topic. As we've just heard from President Croucher, the Australian Human Rights Commission released a position paper on a Human Rights Act for Australia in March this year, and the Parliamentary Joint Committee on Human Rights is currently inquiring into Australia's human rights framework, including the possibility of a Federal Human Rights Act. And I know that many of the panelists, and indeed probably a number of the audience members too, have made submissions to that inquiry. All this is to say that it's a really dynamic time and probably the closest we've been for a long time now to legislating a Human Rights Act. For those of you who are joining this afternoon's sessions, a friendly reminder that we are tweeting the conference and invite you to join the social media conversation. You can find us tweeting at Castan Centre, and we're also using hashtag HumanRights23 for the conference. As with previous discussions, please submit any questions for the panel using the Zoom chat function, and indicate if your question is for a specific speaker and whether you wish to remain anonymous. You'll also see there's going to be some guidelines in the chat around respectful communication. It is now my pleasure to introduce to you our first speaker, Associate Professor Jessie Hohmann, who is an Associate Professor in the Faculty of Law at the University of Technology, Sydney. Jessie is an internationally recognised expert on the right to housing in international law. Jessie's 2013 monograph, The Right to Housing, Law, Concepts, Possibilities, published by Hart, was shortlisted for the Society of Legal Scholars Peter Burke's Prize for Outstanding Legal Scholarship. Immediately prior to joining UTS in 2019, Jessie was Senior Lecturer in Law at Queen Mary University, London. Jessie holds a PhD from the University of Cambridge. Thank you, Jessie. Over to you.
Thank you for this excellent conference. It's so great to be involved and to have a forum to share such important ideas. I'd like to acknowledge that I'm joining you from Darwell country today and that country was never ceded. So Australia is uniquely placed. As the only liberal democracy without a National Human Rights Act, we have the opportunity to enact a visionary human rights framework. This framework should look to Australia's future, not to the past, and it should respond not to the challenges of the mid-20th century, but to the 21st. These challenges include not only climate crisis and the need to protect our precious lands and waters, new technologies and new ways of working and living, continued reckoning with the injustices of the past, particularly with regard to Australia's First Peoples, but also, as this conference program shows, new expressions of old forms of repression and violation, such as torture and the control of women's bodies. These are the reality in which rights violations will occur and to which we must seek to respond. There's no reason, legal, cultural, or political, that Australia cannot enact a strong, forward-looking national human rights charter. And one area where this charter must be strong is in the protection of a group of rights called economic, social, and cultural rights, or alternatively, social rights. These rights, such as the right to adequate housing, the right to decent work, the right to the highest attainable standard of health, the right to food and water, to education, and the right to social security are at the heart of Australian values. They ensure that people have access to an adequate standard of living, not just some people, but every person. They underpin a fair society. So interestingly, Australia was a big supporter of the inclusion of social rights in the international human rights covenants, but it has not brought these rights into domestic law. I think that it was just assumed at the time that Australians already enjoyed these rights. And historically, wages in Australia have been high, public education has been well supported, and our infrastructure has included decent housing and access to food. Social protections have been strong. At least for the majority, social rights may have seemed not a pressing need, but it's really increasingly clear that Australia is not protecting these rights. There's a deep and widespread housing crisis. People can't afford adequate housing and they can't access it. Wages haven't kept up with the cost of living and working conditions have worsened. 2 million Australian households had to go without sufficient food last year, living in what's classed as severe food insecurity. And the cost of medical services is rising, the health system is underfunded, as is public education. Social security is inadequate, leaving people in abject poverty. Social rights provide a response to these challenges. I'm now going to turn to further explain what social rights will require from the government and respond to 3 prominent criticisms of them as a background to how we should treat them in any national human rights framework. Most of my examples are drawn from the right to housing because that's my own area of particular expertise, but I'm happy to elaborate using further examples in the discussion. So to be clear, social rights do not require the government to give everything away for free. A right to housing, for example, is not about giving everyone a free house. What these rights do insist on is that the government provide the framework in law and policy that enables people to access a safe, adequate house, adequate healthcare, education, decent work, food, a social safety net when people can't do so alone. All human rights impose a mix of negative and positive obligations. Negative obligations ask the state to step back and allow people to realise their own rights. For example, the right to housing would impose an obligation on the government not to make laws that allow landlords to discriminate against tenants because they have a history of homelessness, for example. Positive obligations require states to take positive action to help people to realise their rights. So, for example, again, with regard to the right to housing, it might mean taking steps to direct subsidies to different groups. Let's say single parents instead of the construction industry. It might mean regulating the real estate industry more robustly. And in some cases, it might mean providing housing outside the market through social or public housing. If social rights are at the heart of Australian values, why is there resistance to fully protecting them in a new federal human rights charter? There are typically 3 arguments against the inclusion of social rights in constitutional charters or national bills of rights, and each of these deserve a robust rejoinder. The first is that economic, social, and cultural rights, social rights, are inherently vague or unclear and really too vague for judges to make a meaningful determination of them. There might have been a grain of truth to this when social rights were included in the international human rights covenants in the 1960s, but it really holds no water now. There's detailed case law and careful interpretation of social rights, both at the international and the national level, which demonstrates that it's possible to provide clear statements about the legal content and scope of these rights. There are plenty of examples to draw on. For instance, the right to housing is actually included in over 80 constitutions across the globe, as well as at the international level and in regional human rights treaties. At the international level, under the Covenant on Economic, Social and Cultural Rights, a right to adequate housing has been interpreted as having 7 elements, and all of these have to be present in order for housing to be considered adequate. So these 7 elements range from legal security of tenure through to affordability to cultural adequacy. And what each of these means has been clearly set out by the Committee on Economic, Social and Cultural Rights and further explained in scholarly literature, and it's constantly being given further clarity in cases decided under the optional protocol to the Covenant. In Europe, the revised European Social Charter considers the obligation for the right to housing as made up of 3 pillars. First, an obligation to promote access to housing of an acceptable standard. Second, an obligation to prevent or reduce homelessness with a view to its elimination. And third, an obligation to make the price of housing accessible to those without adequate resources. South Africa's constitution also includes a right to access to adequate housing and a prohibition against arbitrary evictions. And there's been a robust judicial consideration of this right in South Africa since the 1990s. So it's hard to maintain that economic, social, and cultural rights are inherently vague. And a second response to this criticism is really a very practical one. If you want a clear social right in your constitution, then take the care to draft the right clearly. So much lies in the drafting of that right. The second criticism is that social rights require the courts to step into territory that's reserved to the legislature and the executive. So the charge here is that judges use social rights to make policy or make law, which should be the domain of the executive and the parliament. So in my view, that fear has a lot more to do with what we're used to thinking about as the role of the courts, and therefore accept as the normal judicial role, than actual differences in protecting social rights when compared to other rights. What I mean there is that we don't think of our judges as enforcing the right to housing, the right to education, or the right to food, perhaps, when we do think of them as enforcing what we think of as classical civil and political rights, perhaps the right to privacy. But I think that there's not as much difference in the judicial role here than is often stated. So even in a system without a formal Bill of Rights, we're used to seeing judges enforce fair electoral laws which protect voting rights. We're used to seeing judges set conditions on detention so that it's humane, thereby protecting liberty and security of the person. These types of decisions are not so different from the vast majority of decisions judges would have to take with respect to social rights. So, for example, protecting against forced or arbitrary eviction to comply with the right to housing would generally require judges to perform a similar evaluation and interpretation of whether, a familiar evaluation and interpretation of whether an eviction is permitted by law and undertaken in conformance with legal safeguards and protections. The third criticism of social rights is that they are just too expensive and should be left to government discretion when budgetary conditions suit. So the expense of social rights is the reason that at the international level, states are allowed to fully realise social rights progressively, taking steps to full realisation over time. But there's a wide misconception that realising social rights is something only for the future because it's too expensive now. There are 2 points to be made in responding to this criticism. First, the option to take steps rather than immediately realise a social right in international law only kicks in when the state actually can't afford the right. So everything that the state can afford now should be done now. This includes measures like repealing discriminatory laws, regulating the private sector. These steps don't have major budgetary or infrastructural implications, and they're not to be put off. Second, recent research shows that fully implementing social rights may actually be cheaper than not doing so. So a recent study carried out as part of an inquiry into whether Wales should change its constitution to include a right to housing found that fully implementing the right to housing would result in a total savings of £11.5 billion over 30 years. The costs of ensuring adequate, decent and dignified housing were over time small compared to the costs of frontline homelessness services, the criminalisation of the homeless, and the health costs associated with substandard and unhealthy housing. I started this conversation with you with a call for a visionary human rights framework for Australia. I think this is within our grasp and that Australia deserves no less. At the same time, I can't claim that a robust protection of economic, social, and cultural rights is in itself visionary. The protection and enforcement of these rights at the international, regional, and domestic levels is now routine. Failing to protect them would be a lost opportunity, and it would not align with the values of fairness and equality that Australia holds dear. Thank you.
Next speaker is Associate Professor Julie Debeljak, who is an academic member of the Castan Centre for Human Rights Law and has been an Associate Professor of the Monash University Faculty of Law since 2013. Julie teaches and researches in the field of international human rights law, comparative domestic human rights law, constitutional law, and human trafficking. Julie has written numerous book chapters and articles on those full range of topics. Most recently, Julie co-edited a book entitled Lawmaking and Human Rights, which is published by the Thomson Reuters Law Book Company. Over to you, Julie.
Thank you very much, Scott, for that kind introduction. And also thank you, Roz, for introducing this session so well with your keynote. My paper today is going to be focusing on enforcement one enforcement mechanism being how we interpret legislation to be compatible with rights. That's proposed by Ros's AHRC proposal, and it's also embedded in each of our 3 subnational Australian human rights instruments. I do for a moment pause on the other mechanism that Ros discussed today, that is the obligations on public authorities. I wholeheartedly agree with Ros about her comments about the need for a freestanding cause of action and a freestanding remedy for violations by public authorities. But I'm not going to focus on that in my paper. For ease of reference in my paper, I'm going to be referring to the Victorian Charter, their version of the provisions. The ACT and the human rights instruments have equivalents of each of the Charter provisions, and I'll explain if and where there are any differences of relevance to us. Now, there are 3 key provisions that I need to focus in on today, and they're on your screen now. The first is Section 7, the overarching limitations provision, which allows reasonable and demonstrably justifiable limitations to be imposed on rights. Secondly, we have Section 32, which provides, so far as is reasonably possible to do so consistently with their purpose, all statutory provisions must be interpreted in a way that is compatible with human rights. And thirdly, Section 36 empowers superior courts to issue a declaration of inconsistent interpretation where legislation cannot be interpreted consistently with rights. Now, these provisions have got analogues in the UK and in New Zealand, and on the screen at the moment, you've got the version of their statutory interpretation obligation. Given these analogues, one could expect that the Victorian approach to its provisions would mimic the approach that New Zealand and the UK have taken, as per their PowerPoint here. And what is that methodology? Well, first you would ask, does legislation actually engage or limit a protected right? If it does, you would then ask whether the limitation is reasonable or justifiable under a general limitations clause. If there is an unreasonable or unjustifiable limitation, thirdly, the judge would then alter the meaning of the provision in order to achieve rights compatibility. And then fourthly, the judge would have to decide whether that altered interpretation is possible and consistent with statutory purpose. There are then 2 conclusions that are drawn from this. If the rights compatible interpretation is possible and consistent, that is a complete remedy to the rights issue. However, if the rights compatible interpretation is not possible or not consistent, the judge then may decide whether to grant a non-enforceable declaration of inconsistent interpretation. Now, I want to highlight there is one key difference between the Victorian and the UK instrument, and that is the addition of this phrase consistently with their purpose in Section 32. In terms of the legislative history of the Victorian Charter, that phrase was intended to codify the British jurisprudence on interpretation to that point in time, which is mainly represented by the Castan case. Indeed, 3 individual Supreme Court judges in 3 individual cases approached the Charter's provisions consistently with the UK methodology, and in essence, they were accepting that the Charter was intended to replicate the British approach. Now, please don't freak out, because I do have to speak about Momcilovic, because this 3-judge court actually decided in the opposite direction to the 3 individual Supreme Court judges. The Victorian Court of Appeal in R.B. Momcilovic rejected that approach. The Victorian Court of Appeal held that Section 32 enacted quite a unique interpretive obligation, and it found that those words consistently with their purpose were actually words of limitation that stamped Section 32 with quite a different character to the UK instrument. According to the court, the significance of Section 32 is that Parliament has basically embraced and affirmed the principle of legality. It then proposed its own methodology. Okay, so the Victorian Court of Appeal held that Section 32 does not create a special rule of interpretation, but rather it forms part of a body of interpretive rules to be applied at the outset. So their methodology as proposed goes like this. Firstly, you are to ascertain the meaning of a relevant provision by applying Section 32 alongside the common law principles of statutory interpretation and the Interpretive Legislation Act. Secondly, so interpreted, you ask, does that provision then breach a human right? If it does, you turn to the third question and you apply Section 7(2) limitations to determine whether a limit imposed is justified. Now, there are two key points to take from that methodology. Firstly, under that methodology, there is no role for Section 7 limitations provision analysis when you're deciding whether legislation is compatible with rights. Rather, Section 7 is used as a preparatory step for judges in considering whether to issue a declaration of inconsistent interpretation. The second key point is that rights-compatible interpretation is undertaken at the outset of the interpretive journey and thus has no remedial force. Now, this is in contrast to the New Zealand-UK methodology, which commences with ordinary statutory interpretation techniques, and then it relies on rights-compatible interpretation as a remedy when legislation is found to have imposed an unreasonable or an unjustified limitation. So when the Victorian Court of Appeal states things like Section 32 does not create a special rule of interpretation, the honours really mean that Section 32 does not create a special rule of remedial interpretation like the UK/Castan interpretation. Now, this case went on appeal to the High Court and there was no resolution. In fact, not only did the High Court not resolve the differences amongst the Victorian judiciary, if anything, they muddied the waters even further. So at the risk of a major gross overgeneralisation, the High Court was split as follows. 3 judges were in favour of the Victorian Court of Appeal decision. 3 judges favoured the individual Supreme Court judge's view of the Charter, and 1 judge gave us an expansive view of the Charter but then found it to be unconstitutional. So where does that leave us? The scope and meaning of both Section 32 and Section 7 are contested, and the manner in which those 2 provisions interact is disputed. And this has really stifled enforcement of the Charter, particularly demonstrated by the lack of reliance on Section 32 in litigation. Section 32 interpretations are not being pursued in court, both because of the complexity of the jurisprudence and the lack of value add, where Section 32 is merely a codification of the principle of legality and Section 7 is sidelined. Now, in my opinion, this is problematic. Firstly, it's problematic because individuals are not receiving the benefit of the intended benefit of rights-compatible interpretation. And secondly, judges are actually not fulfilling their envisaged role of fixing rights incompatibility through interpretation. So by design, a statutory instrument should encourage judges to fix rights incompatibility wherever possible, rather than relying on the Parliament, with its already tight legislative timetable, to be adjusting legislation where that legislation or the interpretation of that legislation can be adjusted by the judiciary. So here we are to the solutions. There are 2 solutions to this problem. The first is to actually provide a definition of compatible with human rights that includes limitations analysis. And the second solution is to get rid of that phrase consistent with their purpose. And I'm absolutely delighted to let you know that the Human Rights Commission's proposal supports both of these. So I'm just going to walk you through both in turn now. With Section 7, you'll note that the Queensland Human Rights Act and the AHRC proposal both provide a definition of the concept compatible with human rights that includes limitations analysis. That is, we actually consider legislation to be compatible with rights where that legislation imposes a limit, but that limitation is reasonable and demonstrably justified. And you'll see that I've put the Section 8 Human Rights Act Queensland version on the PowerPoint for you. This actually fixes 2 main problems. First is doctrinal. It's most unusual for an external limitations provision to be part of the enforcement/remedial analysis of a violation of rights. Rather, it's usually part of the assessment of whether a right has been violated in the first place. So the definition helps fix that problem. Secondly, it also ensures that limitations are considered before a breach of right is found, which actually supports the New Zealand and UK methodology as well as parliamentary sovereignty. If a statute does not limit a right, if a statute does limit a right, but that limit is reasonable and justified, there is no breach of rights. It's only where a statutory provision limits a right and that limitation is not reasonable or justified that there is a breach of rights, and at that point only do we need to get the judges involved. Turning to section 36, I need to digress, section 32, I need to digress for one moment. I want to focus firstly on the differences between constitutional and statutory instruments when it comes to remedies. Under constitutional instruments, the remedy is invalidation of the rights incompatible law. The law is no longer operative, so the law can no longer unreasonably or unjustifiably infringe rights. Whereas under statutory instruments, rights compatible interpretation is the remedy. If a law unreasonably or unjustifiably limits a right, a complete remedy is to give the law an interpretation that avoids the unreasonable or unjustifiable limitation. Now, it's my opinion that section 32 of the Charter was intended to be a remedial provision, and the Federal Human Rights Instrument should also allow for remedial interpretation. So hence my preference for the UK New Zealand method. How do we do this? Well, we do this by removing the phrase consistent with their purpose from the equivalent of section 32. Recall, it was the addition of this phrase that prompted the Victorian Court of Appeal to interpret the Charter differently to the UK instrument. And again, I'm delighted to say the Australian Human Rights Commission proposal does delete those words. It states all legislation is to be interpreted so far as is reasonably possible in a manner consistent with human rights. This brings me to the strength of the remedy, okay? How far can rights compatible interpretation be pushed and still be considered to be legitimate judicial interpretation that is possible and not an illegitimate judicial act of legislation that is not possible? Now, time doesn't permit me to go into the detail, and you can read my submission to the inquiry if you care, but I prefer the Gaidan approach. Why? Strong remedial rights compatible interpretation, firstly, is part of this dialogue scheme underlying statutory human rights instruments, and secondly, it doesn't undermine parliamentary sovereignty. Parliament can always respond to unwanted or undesirable rights compatible judicial interpretations by statutory provisions that clearly implement incompatible legislation. The next thing we need to think about is the phrase, so far as is possible to do so. This phrase, and particularly the word possible, becomes the brake on judicial power. What is possible is judicial interpretation. What is not possible is judicial acts of legislation. And there's three sub-things we've got to look at when it comes to this idea of possibility. The first is this issue of conflicting parliamentary intentions. What happens when we get a conflict? So, for example, firstly, we have the rights instrument enacting Parliament that says legislation should be interpreted compatibly with rights. And then we might get a later Parliament that enacts a law where it's clear that the intention is to enact rights that are legislation that are rights incompatible. Well, under the current drafting of the Victorian Charter, the latter intention automatically trumps the former. However, this will not be the case under a federal diagram based on the Human Rights Commission's proposal. What we're going to need to do here is resolve conflicts of intention via close analysis, okay? Are those two intentions really in competition? And if so, can they be reconciled? So first, thinking about the intentions. If legislation is actually enacted after the Federal Human Rights Scrutiny Act, the Executive and Parliament have got mechanisms through which to convey rights incompatible intentions, and those mechanisms must be used. So, for example, they must use clear statutory legislation that ideally ensures only one interpretation is possible. Secondly, They should also use a clear statement of intention which conveys parliamentary's intention to limit rights. Thirdly, they should be issuing a statement of incompatibility under Section 8. And fourthly, parliamentary debate that engages with any Section 7 report by the Parliamentary Joint Committee, which indicates rights incompatibility, should be had, and Parliament should indicate clearly that regardless of the concerns of the Parliamentary Committee, they wish to proceed with legislation regardless. Now, these mechanisms ensure that a clash of intentions is readily identifiable, but more importantly, they also develop this idea of a culture of justification for the rights impacts of legislation. They improve transparency and accountability for the rights impacts of legislation and policy. The next issue comes down to reconciliation. Remember, here we are thinking about judicial interpretation, not judicial legislation. So, what intention should trump? Lord Nichols in Gaydar did not hold that rights-compatible intentions of a rights instrument enacting Parliament will always trump the rights-incompatible intention of a later Parliament. All he said was that sometimes they may trump, sometimes they may not trump. It's important to look at the circumstances when the rights-compatible intentions may not trump a rights-incompatible intention. In Gaydar, Lord Nichols said, remedial interpretation does not allow the courts to adopt a meaning that is inconsistent with the fundamental features of legislation. A remedial reinterpretation must be compatible with the underlying thrust of legislation and must go with the grain of the legislation. Now, the final thing I want to briefly mention is possible interpretation consistent with the common law and statutory rules of construction in Australia? Well, again, I asked you to consider the set of guidelines offered by Lord Nichols about what may be achieved via rights-compatible interpretation. He states things like, language may be interpreted expansively or restrictively. A judge may be required to read in words to change meaning, or a judge may modify meaning to avoid injustices and absurdities. These styles of judicial interpretation are within or incidental to the normal range of judicial interpretive powers in Australia. In other words, they are possible exercises of proper judicial power. Now, the last point that I want to make comes down to this idea of reasonably possible. Having removed the phrase consistent with their purpose, the Human Rights Commission is now recommending inserting the word reasonably as per this PowerPoint. I don't support the insertion of the word reasonably for numerous reasons, so this aspect I don't agree with. Why don't I agree with it? Well, firstly, the concept of reasonable interpretation is associated with the New Zealand Bill of Rights Act. The British Parliament actually expressly chose not to adopt the New Zealand model, and the subnational Australian jurisdictions have modelled their instruments on the UK and not New Zealand. Secondly, it's unclear what the word reasonable would add to the word possible. And the case for adding two breaks on power to the judiciary has not been made out. Thirdly, if we've learned anything from the Momcilovic litigation, it is that Australian courts will attach meaning to the alteration of words. Just as the courts attach meaning to the words consistently with their purpose, we should expect courts to attach meaning to the word reasonable, and that again might threaten the remedial character of the provision. Fourthly, we're asking for a weak instrument anyway. We're only asking for a statutory instrument, not a constitutional instrument. So having already asked for a weak instrument, I'm not in favour of weakening it further by adding the word reasonable. But fifthly, it's my view that the Australian Human Rights Commission does not appreciate the work being done by possible. I think possible is enough. It doesn't need to be reasonably possible. And finally, the Australian Human Rights Commission position essentially adopts the Law Council's position. And it's not clear to me how the Law Council's position on reasonably possible is any different to that of Gaydar. I won't pause on this final slide because I've spent too much time already, but I'll conclude by saying the Human Rights Commission paper is fantastic. It navigates a path through some of the most intractable debates surrounding the adoption of federal human rights legislation, and it's commendable for that. We now await impatiently the outcome of the Parliamentary Joint Committee, but hopefully we will soon have a Bill of Rights for Australia. Thank you.
I encourage everyone to go and read your submissions, which are available on the PJCHR's website. So do that at the end of today. Our third panelist is Professor John Tobin. John is the Francine B. McNiff Chair in International Human Rights Law in the Melbourne Law School at the University of Melbourne. John is also co-director of studies in the Human Rights Program in the LLM program and co-director of research in human rights in the Institute for International Law and the Humanities. John's research interests cover the broad field of international human rights law, with a particular interest in children's rights and the right to health. In addition to extensive work within the Academy, John also provides human rights training, advice and pro bono consultancy to various governmental and non-governmental organisations. Thank you, John. You have the floor.
Thanks, Scott, and thanks so much for having me this afternoon as part of this really exciting convention. I'd also like to start by acknowledging that I'm coming to you not from Darabin Creek, that's the background where I live, but from the lands of the Wurundjeri people, and pay my respect to the elders past and present. I also discovered a really important document last night that perhaps many of you know of. It's called the Aboriginal Charter of Rights, written by a really important Aboriginal poet, Udukru Nunukul. So I encourage you to look at that in your own time as well, to get a contrast with the very technical discussion we're having today, with some of the really important sentiments expressed by our Aboriginal leaders in this space as well. My role is not to discuss Mom Silvich. I'm still having sort of chills about that conversation because it's such a hard case to understand, but rather it's to really explore the dimensions of Chapter 7 of the AHRC position paper as well. And can I also congratulate Roz and her team. It was an extraordinary document, perhaps the most contribution in this space for a long time around the importance of a Human Rights Act for this country as well. So what I want to try and do in my sort of 15 minutes is two things. One, to explain the duty outlined by the Commission, and then actually offer answers to 10 of my own questions that arose when I read this chapter as well. So first I'll start with the proposal itself. It's sort of got two parts. Part one is to impose a binding duty on public authorities with obligations under the Human Rights Act to ensure the participation of First Nations people, children and persons with disability in relation to decisions that directly or disproportionately affect their rights. So that's the first part. The second part is to impose a non-binding duty for proponents of legislation to facilitate participation during the lawmaking process and to detail such measures in the statement of compatibility. Okay, now those two things are fairly radical in the scheme of things when it comes to conversations around charters of rights in this country as well. And when I reflected on that, I should add that back in 2005, I made my own submission to the Victorian Consultation Committee when I actually suggested the same thing. So it's kind of nice to see these ideas coming up nearly 20 years later as well. So my first question that I thought about, what I want to try and reflect on, is what is the basis for this proposal? Where does it come from? And for me, there are three sources, and these are all set out and detailed in fact, Chapter 7 as well. I encourage you to read that in your own time. The first is that these three cohorts that are given special attention all find support for this claim in international instruments. So the Declarations on the Rights of Indigenous Peoples, the Convention on the Rights of Persons with Disabilities, and the CRC all have dedicated provisions that actually set out a specific participation duty or obligation on states. The second point is one around what we might talk about as a moral foundation, or the ideas around democratic legitimacy as well. So historically, and of course in contemporary times, each of these groups are often marginalised in decision-making within Australia. And on that basis, you could argue that a special participation duty is justified to ensure their participation in decisions that affect their lives as well. The third is instrumental. And I think this shouldn't be lost because for many of us, and I imagine in conversations around the exposure draft, this procedural duty might get left on the cutting floor. When it comes to the instrumentalist argument, it's in fact the idea is that once you engage with these groups in decisions that affect their lives, you actually end up with far more effective and more efficient outcomes in terms of policy and legislation. And if you look at examples of that, which are also listed in the Commission's paper, the Northern Territory Intervention is a classic example. When you don't talk to Indigenous people about things that affect their lives, you end up creating really bad policies that cause more harm than good. So from a legal, moral, and also instrumentalist perspective, there's a really strong foundation to think about inclusion of this procedural duty in the new Human Rights Act. The second question that sort of struck me, and I imagine strikes most of you, and can congratulate those of you who are still online at sort of 2:30 on a Friday afternoon, is why is the proposal restricted to 3 groups, and is this problematic? So I suppose the answer to that question is, if your focus is international law, the answer is easy to justify that only those 3 groups get this special participation duty. But is it sufficient justification when we think about other groups in our society that may also be excluded from participation in decisions around matters that affect their rights as well? People from migrant backgrounds, refugees, the elderly, and other vulnerable groups. And I think this is something to reflect on, to be honest. And so a question perhaps to the group, and of course the Commission as well, to think about moving forward is, would it not be more appropriate to have a broader, more procedural duty that would actually arise when the proposed service, legislation or policy in question was likely to have a direct or disproportionate impact on a particular group of individuals that require extra efforts to enable their participation in that decision-making process? So I think that's something to reflect on, and I think there'll be something that's a very live issue if an exposure draft is in fact prepared, which includes this procedural duty. Question 3, is there anything within the current Australian legal landscape that's actually equivalent to this procedural duty? This is an important question. I can see what the Commission's doing here. For many of those who work in this space will almost be alarmist. Why is this being included? Where's it come from? Isn't this something that actually exists in other schemes around the world? And I think if you look at Chapter 7, you'll see the Commission saying this isn't such a new idea. In fact, if we go to both the common law and we look at existing statutory schemes, we'll see, in fact, there's a long-standing tradition of including participation the way we think about doing decision-making in this country. So the Commission refers to the role of the common law, and particularly ideas around procedural fairness that demand that individuals have a right about matters that will actually have an effect on their entitlements or interests or rights in current circumstances as well. And of course, many acts in specific areas may also require that there is consultation with affected parties, for example, local government as well. So that's, I suppose, to set the scene that consultation participation isn't actually foreign to our policy decision-making processes, but at the same time, there's nothing that's as widespread or as ambitious as the duty proposed by the Commission itself in its position paper 2. So question 4 is, well, there's nothing like this in Australia. Is there an equivalent provision like this in other jurisdictions? Well, the answer is not really, to be brutally honest. So if you look at the models that we've been discussing in terms of what's happening in Victoria, the ACT, Queensland, the UK, New Zealand, Canadian models, or other, in fact, constitutions, we don't see something as explicit as this, and certainly not directed towards these 3 cohorts. And at the same time, I think it's important to recognise that the idea of consultation participation is a feature of the human rights landscape in other jurisdictions and a whole range of expressions as well and formulations. In the UK, we have what's called the gunning principles, which arise in certain contexts and identify when a duty to consult would exist. In Canada, there are guidelines around consultation with Indigenous peoples that are really critical to issues around reconciliation. Similarly, there's a similar obligation in New Zealand under the Treaty of Waitangi, which talks about the need to have consultation with Maori people when it comes to issues that affect them directly as well. In Scotland, I will just highlight in my own area, there's a Scotland Children's Act, which actually does have a direct incorporation of Article 12. And that's seen as being, I suppose, what it's described as being quite revolutionary in its commitment to children's rights, but it actually incorporates Article 12, which imposes a really explicit obligation on states to ensure that children's views are heard in all matters that affect them, and those decisions are taken into account in decision-making as well. There are also a number of constitutions that have various formulations, particularly when it comes to children, around how their views might be taken into account as well. So the idea isn't entirely foreign to the international landscape, but at the same time, the formulation proposed by the Australian Human Rights Commission is quite unique in what it's asking as well. Question 5 is, well, how would the duty be formulated? And again, this is detailed at length. I won't repeat it, but essentially it's important to recognise that it would reflect the formulations adopted in the international instruments. Why is this important? What the Commission is saying is, if we take the international obligations Australia's accepted seriously, then we have to actually incorporate those standards into our domestic legislative framework as well. So that wouldn't be the same for each of these cohorts. It will be tailored to reflect the standards under each of the respective instruments as well. Importantly, the Commission's also identified the need to accompany these formulations with guidelines about how to operationalise the actual consultation process in practice. Question 6, how will the duty actually operate in practice? And again, it will be different for every single group to ensure consistency with that international standards. But the overarching principle is the same, okay? Consultation will be required if there's a direct concern or disproportionate impact on a group or individual within each of those 3 cohorts. Once that impact or concern arises, that triggers a consultation duty. How would in fact this be undertaken? And this is a conversation we need to have beyond today, but in general terms, the Commission's explained that the decision maker would need only to show that they were sufficiently fair and representative consultation. This is really important. What's it actually mean and look like? Sufficiently fair and representative consultation with the affected parties, not the participation occurred comprehensively with all relevant bodies or individuals. Now you can see there's a lot of scope in terms of mapping out what that would look like in terms of what is sufficiently fair and on what circumstances would you have to have much more detailed conversations with affected individuals as well. Now the last part is also really important as well. What would happen if there wasn't compliance with this duty? And the Commission has said there would be no discrete cause of action available based on failure to enable participation. What would actually happen is that failure might become relevant when looking at whether in fact there was a violation of another right under the new Human Rights Act, and whether in fact the failure to enable consultation with respect to that right would lead to a violation as well. So another thing that I think is important to flag here is how does this proposal relate to the voice proposal? Now, clearly there's significant intersection between what the Commission is suggesting and what the whole idea behind the voice as well. And this is identified in the Commission's paper too. And we can explore that in consultation and question time. But essentially, the voice, if adopted, and thankfully and hopefully it may well be, would provide an example of a mechanism that would enable, okay, the decision makers to obtain the views of Indigenous or First Nations people. So it's an illustration of how this procedural duty might actually operate in practice. Question 8 is this proposal radical? So this is, I think, really interesting. I've got a yes and a no in my notes here. No, and I say this on the basis that if we think about what a human rights-based approach requires when it comes to the decision-making by our government agencies and our political leaders, participation is absolutely core to that model. Anyone who works in international human rights law knows that a rights-based approach has as its core participation and engagement with those who might be affected by decisions being taken by those in positions of power as well. So in that sense, this is not sort of radical or unique or original at all. And if you think about, particularly when it comes to people with disability, the phrase "nothing for us without us" is really central to how that entire model works. And the same thing applies to Indigenous people, First Nations people, but also to children as well. So if we're serious about human rights, then we have to listen to those whose actions are affected by our actions as well. At the same time, within Australia, I think this is an extremely radical proposition. We haven't, as Roz, Jessie and Julie have all identified, had the, I suppose, courage or maturity as a nation to actually commit to a robust human rights framework which will allow for a cause of action to hold those accountable when their rights have been violated. So therefore, then to ask our leaders to say, well, now we're actually demanding that you have an obligation to engage with, speak to, listen to, and act upon the views and voices of those who are most vulnerable in our community, I think is significant in terms of the political landscape within this country. It would transform decision-making to become far more inclusive. Now, I think that shouldn't be radical, but I think in many respects at the moment in this country, it is. That I think becomes relevant then to the question of, well, what's the prospect of this actually being adopted? We'll come back to that later on as well. Question 9, which I think is very important, is there a risk that this process or this duty itself could be reduced to a tick box compliant exercise without there being any general consultation? Now, imagine if you spoke to most of our colleagues who identify as being Indigenous or First Nations, or people working, people who identify as having a disability, they'll no doubt complain regularly that consultation may often be a regular feature of policy making, but it lacks substance. It's tick box, okay? There's compliance approach rather than substantive engagement. This, I think, is a really serious issue. So if we were to adopt and implement this duty, we'd have to ensure that in fact it was genuine and substantive as well. How we do that, I think the Commission quite rightly identifies that it would have to identify and draft and prepare sufficient guidelines which talk about what is a substantive obligation rather than a mere compliance obligation as well. Now, thankfully, there are many, many guidelines that exist internationally that will allow for us to develop those principles, but I think it's a serious consideration as well. One of the things that perhaps has happened under the current system at the federal level is we have, of course, an obligation to scrutinise legislation against international standards, but often that's very much a tick box exercise as well. So a robust duty would require significant education, awareness raising, training, and guidelines to accompany it as well. The last question is then a personal one for me to answer. Should then a new Human Rights Act include such a duty? And of course, we should all form a view on that if we are to place our submissions before the committee and also the exposure draft. And this is it. Iris Young has said, the normative legitimacy of a democratic decision depends on the degree to which those affected by it have been included in the decision-making process and have the opportunity to influence the outcomes. Now, if you believe in this idea, then the answer is clearly yes. We need to have a process in this country that would actually allow for our decision makers, whether it's in the executive and the public service, but also those who are proposing legislation, to be really directed towards having an explicit obligation to ensure that they are in fact engaging with and in taking seriously the interests and views of those who are affected by those decisions. And importantly, a really obvious place to start is with identifying our First Nations people, Indigenous, also people with disability, and finally children as well. So on that note, I'm going to finish. Hopefully I've made up some time because I know we're a bit behind time as well. And hopefully we've left some time for conversation, discussions about what I think is a really interesting and novel proposal, but one I think which will generate significant pushback as well. So on that note, thank you for having me, and I'll wrap it up. Thanks very much, Scott.
Thank you, John. Our final panelist is Kate Eastman, AMSC. Kate is a senior counsel at the New South Wales Bar and is currently the senior counsel assisting the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability. Kate has over 30 years experience in dispute resolution and advocacy across a number of areas of law, appearing in federal, state and territory courts and tribunals, and is a recognised expert in human rights law. In 2021, Kate was made a member of the Order of Australia for significant service to the law, to human rights and to professional organisations. Thank you, Kate.
Well, thank you, Scott, and thank you to the whole of this panel. It's been so interesting to listen, and it's an honour to be involved. Thank you also to Ros for her keynote address. I'm coming today to join you from the Gadigal lands for the Eora Nation, and I pay my respects to all First Nations people. Today, my comments are entirely my own comments. They don't represent the views of any Royal Commissions or any other of the bodies that I'm involved in. But I want to start by really talking and thinking about remedies as a consequence of having a human rights framework. As a litigator, I spend a lot of time thinking about causes of actions, remedies, courts procedures, whether it be in the common law, in equity, or looking at a range of statutory rights. And these considerations are always directed to procedural issues, substantive issues, but often to strategic issues. Where can my client get the most effective remedy? Or if I'm on the other side of a matter, are there grounds to resist their remedy in certain circumstances? So the importance of enforceable and effective remedies is, as you all know, a core principle of common law systems. We go back to 1803 and the US Supreme Court's decision in Marbury and Madison, and Chief Justice Marshall there made it very clear that the essence of civil liberty certainly consists of the right of every individual to claim the protection of the laws when he, I'll call that neutral, receives an injury. In international human rights law, the right to an effective remedy is itself a substantive right. It's a core part of many of the international human rights treaties, and you'll be familiar with, for example, Article 2.3 of the International Covenant on Civil and Political Rights. The concept of an effective remedy has evolved in international law to really focus on two core components: the procedural aspects of a right to a remedy and the substantive remedy itself. The The procedural rights are very important because there must be an effective pathway to achieve a remedy, and that pathway itself must be fair. We see this embedded, for example, into a right to a fair trial. For substantive remedial provisions, there must be some consequence if there has been a breach of rights. And in 2004, the UN Human Rights Committee describes the concept of remedies through reparations as follows: that a reparation can involve restitution, rehabilitation, and measures of satisfaction. They may include public apologies, public memorials, guarantees of non-repetition, changes to relevant laws and practices, as well as bringing to justice the perpetrators of human rights violations. And many of you will be familiar with the important work achieved by the Van Boven principles on redress and support for victims of gross violations of human rights. Well, turning to the domestic arena, there are numerous examples of Australian laws that provide the pathway to enforce some human rights and secure some remedies for particular rights in particular areas. So some of the important examples are our federal anti-discrimination laws, the operation of the Fair Work Act in relation to employment rights. We see rights around defamation, privacy, and even old remedies such as habeas corpus. The range of remedies are quite broad, and the persons against whom we can secure a remedy are also broad. Our remedial provisions are not limited just to government, departments or agencies, but they may extend to corporations and individuals who engage in conduct that may infringe a person's rights. So, though, when it comes to a discussion about remedies being included in one law that brings together the suite or range of human rights reflected in international instruments, the discussion about remedies changes. The discussion inevitably focuses on the problems of either providing a pathway to achieve a remedy or the remedies itself. The idea that the person whose rights have been infringed, who've suffered abuse as a result of contraventions of human rights, are very rarely included in any discussion about what are appropriate remedies. In my view, and I'd welcome a conversation about this, I actually think that dialogue models of human rights has allowed us to downplay the importance of individual remedies. And in effect, the dialogue model excludes the individuals from being part of the dialogue. The dialogue model sees individuals, those are the beneficiaries of rights, as passive. The assumptions in a dialogue model is that if the three arms of government are working effectively and the three arms of government are acting consistently with human rights, considering human rights, interpreting human rights, then what do individuals need by way of their own voice or their own participation by way of seeking a personal remedy? So this has been quite convenient in some of the discussions that we've had about human rights reform in Australia, because some of the older discussions have very much been influenced by the fact that any discussion about individual remedies, and particularly compensation, may actually jeopardise the success of securing a new Human Rights Act in a particular jurisdiction. And so we see remedies becoming the playground of the political compromises. The arguments are often run that if we don't include remedies, or we limit compensation, or we limit what the procedural pathways might be, we may have more success in persuading government to enact a Human Rights Act. Now, it's not up in the time available enough for me to sort of go into the deep, dark past of how the Australian Human Rights Commission, dealing with its human rights jurisdiction that's receiving complaints and writing reports, or the ACT, Victoria and Queensland models, have all considered, addressed, and in some cases rejected a personal remedies model. The remedies that are available under our existing models are a little opaque. They're very difficult to access, and even more recent reforms, I think, have not really persuaded individuals that this is the best place to seek a remedy. For my part, there's never been a cogent reason as to why Human Rights Act should exclude the right to both procedural and substantive remedies. But, and I think, Ros, you've commented on this a little earlier, but some of the common reasons that are often trotted out seem to be very much focused on the problem of lawyers, particularly litigators. So that's me. I'm sure there's a few others in the audience today. So first of all, it will create a lawyer's picnic. And I assume this means that the picnic that we all have after we've stopped chasing ambulances and that we need repose. But what sits behind the notion of the lawyer's picnic is, one, to give a colour and a flavour that lawyers will own human rights legislation and that lawyers will use both the procedural and substantive remedial pathways to pursue financial gain and implicitly take advantage of victims. So this is an argument that's often trotted out. The next one trotted out is that the lawyers, together with their clients, will clog up the courts, and that the courts will be full of human rights cases, and that will affect the capacity of the courts to manage litigation. Associated with that argument is additional costs in relation to the litigation. And then worse, decisions will be made by unelected judges who will make orders that may interfere with important government policy or budgetary matters. So these arguments have long been used in the human rights debates. And I must say, in New South Wales, a former Premier, Bob Carr, was sort of championing these things. If you want to have a look at his views, they're recorded in articles in the Canberra Times, the Weekend Australian, throughout the period 2001 to 2007. But one thing I really have thought a lot about is that the debate about access to remedies and the role of lawyers is often a proxy to question the substantive rights themselves. So again, just using Bob Carr's word, in one of his articles, he looked at the situation in New Zealand and said, within 7 years of the New Zealand Bill of Rights coming into action, all that had happened was that the undeserving criminals, drink drivers, and those who might be keen on terrorist activities had been using bills of rights to try to challenge evidence, to overturn convictions, and to evade justice. And so this idea that remedies is somehow linked to the undeserving and that remedies will create opportunities for those who shouldn't have those opportunities very much sort of reflect that undercurrent political debate. So I then come to the very important work of the Australian Human Rights Commission in the Free and Equal Position paper. Part 11 of the paper, and if you've got it with you, it starts at page 334, considers a range of different causes of actions and remedies. It considers pathways of complaints through to the Australian Human Rights Commission and then on to a court. It looks at administrative law and judicial review pathways. It poses a possibility of a new tribunal to undertake a form of merits review in human rights matters, as well as making important recommendations on the question of who has standing to bring a complaint and costs. This is a very welcome discussion. But I think the Commission, with all respect to it, is taking a very cautious approach on the question of both procedural and substantive remedies. The key recommendation is essentially to replicate the model that presently exists for dealing with complaints of discrimination, unlawful discrimination. These are models that require individuals to lodge complaints with the Australian Human Rights Commission. The Commission will then investigate and attempt to conciliate the complaint. And if that's a process that's unsuccessful, then the complainant can elect to commence a proceeding in the federal court to seek remedies. Section 46P04 of the Australian Human Rights Commission Act sets out the remedies that a federal court can order if a complainant is successful with his, her, or their case. In some senses, I understand why this proposition has been made, because it's a very safe approach. It's an approach that we're familiar with and we've used and has operated in this form for about 22 years. But we need to ask whether or not the existing regime has been effective in protecting rights. It has not been effective in protecting the rights of all people to live free from discrimination. We only need to look at the very poor success rate for claims brought under the Racial Discrimination Act. And for reasons that might be obvious, I've looked very carefully at the operation of the Disability Discrimination Act. And there's only been one successful claim based on disability harassment over the 30 years that the Disability Discrimination Act has been in operation. So we need to look critically at the operation of our discrimination laws, both in the procedural aspects, but also in the substantive remedies. And I think we have the opportunity to really now take some innovative thinking, both on the procedural and substantial remedial pathways. Some of the thoughts that I want to raise for discussion is whether it's possible to move from what I call a reactive or responsive model to a proactive model. Our laws require there to be a breach of a person's rights before the right to remedy is engaged. So the breach has to occur and then it becomes a reactive model. In that reactive model, all of the onus rests on the victim to initiate a claim. It is the victim who has to lodge a complaint, and then the complaint becomes the trigger for action. The standing rules effectively mean that we're focused on the experiences of individuals, but there is a possibility for class actions, but very little opportunity to address systemic experiences or patterns of behaviour, as opposed to a very heavy focus on individuals. This is perhaps a consequence of our constitutional arrangements, where our courts exercising judicial power under Chapter 3 of the Constitution can't give advisory opinions, they can't deal with hypothetical matters, and that they have to deal with the matter being an actual dispute that can be appropriately adjudicated. The other really significant aspect of using the existing model is to think about the role of the respondent. With federal discrimination laws, the respondents might be individuals, they might be small businesses, they might be corporations, and they might also be government entities. A Human Rights Act model is essentially going to have one style of respondent, and that is the Australian government in its various emanations. There is a vast disparity in the power, resources, and knowledge of the Australian government and the victims who make complaints. The victims might only ever use the Human Rights Commission once in their entire lives, but the Australian government will be its frequent flyer. It'll be at that high level of platinum frequent flyer. And so that means that you build into the system a degree of advantage for those who frequently use the processes. They will be familiar with the personnel, the language, the procedures, and what usually happens. That creates great disadvantages for victims who do not have that experience or access to those resources. The other disadvantage, of course, to victims is that if they also are required to prove their cases, so they bear the onus of proof, and they do not have access to the documents and the material of government, this also places victims at a significant disadvantage. The next point is the lack of transparency in conciliation processes that are confidential, particularly if the outcomes are also confidential. If people need to see a Human Rights Act in operation and a new law that might result in governments having a view that it's good to settle everything confidentially and privately, will mean that we don't learn from how these laws can work in practice, how the rights are being interpreted, and to also give people the confidence to see that if others can bring complaints, they can too. I also think there is an important need for there to be a direct cause of action to the court without having to bring all cases through the commission. Now, part of this is that sometimes it's a very slow process to have a matter conciliated, and there will be some cases involving prospective breaches of rights where a person may need to go to court very quickly, not just on an interlocutory basis, but also on a final basis. Then we need to think about remedies. The present arrangements mean that there are no opportunities to secure civil penalties under the AHRC Act. This will change from December in relation to the Commission's jurisdiction to seek civil penalties in relation to some aspects of sex discrimination law, but it's not across the board. Civil penalties in the Fair Work arena have proved very effective in ensuring that those who bear the obligation to comply with the law will do so. And related to that, I think that there should also be the option for victims not to have to bring the complaints themselves. We need something like the equivalent to the Fair Work Ombudsman in a human rights arena to be a strong regulator, not only in an educative function, but to also be able to commence litigation, to even up and level out the playing field between the power of a government and the resources of a regulator. So it means strong regulation, but an effectively and well-resourced regulator. So there are a few thoughts that I wanted to share today, but I very much welcome the discussion. Thank you, Scott.
We have about 10 minutes now for some discussion. And so I would encourage us all to come back together, and I wanted to, I guess, zoom out slightly and ask a question about advocacy around the Human Rights Act. There are lots of reforms on foot at the moment in the human rights space more broadly, particularly around the voice to Parliament, as John mentioned in his presentation. And I wanted us to explore perhaps how the sort of debate is playing out in the voice and how that might reflect on how the Human Rights Act will play out in the public arena. So perhaps, John, considering you mentioned it in your presentation, if you might like to begin. I don't want to put you on the spot, but thank you.
Yeah, thanks, Scott. That's a pretty big question, just quietly. But I think the key response to that is clarity of information. And what we're seeing with perhaps the Voice campaign now was getting that clarity with respect to the impact of the referendum as well. And so my fear would be with the same thing, if exposure draft is released, or even this consultation taking place now, is that there'll be a lot of concerns that are raised around the scope of rights, the measures for enforcement, the impact of the procedural duty, that may in fact not actually identify with clarity what the actual impact will be. So for those of us who are advocating for the Human Rights Act, I think the obligation then is on us to be really clear. For me, there's always been a what's that old phrase, that the sky is falling in approach when it comes to the Human Rights Act in Australia. We're always scared that the whole world's going to crumble, and every jurisdiction that's adopted any scheme, that pretty much everyone bar us, everything's gone on okay. The world hasn't stopped, in fact, and it's invariably improved. And I think the point that Jessie made was even the right to housing. There'll be an outcry. Oh my God, how can I have a right to housing? You actually look at it from every perspective, you legally, morally, and fiscally, instrumentally, it's often actually more efficient to actually have these rights built into our systems. We have proper processes to identify how to balance conflicting interests and obligations, to allocate scarce resources as well. So I think, to go to your point, clarity around how we advocate, anticipating anxiety. I think it's reasonable that people will have fears about anything that involves change. So part of the obligation then of those who advocate this new model is to say, look, we hear what you're saying, but we can reassure you that your concerns aren't in fact as warranted as you think may be as well. But I mean, it's a really important question. I'm sure others will have a similar response to it. And again, as I looked at this presentation, I wrote submissions on these issues back like 20 years ago, and the same concerns are being raised, and the same concerns often have no foundation, but they still inform what we do as a society as well. So if we can address those and move past them, then in fact, we may see change for the better as well.
Does anybody else have anything to add on that? Julie, I know you just unmuted, so perhaps you have something to add.
Yeah, John, when I was writing my submission to the inquiry, I was just like, not another submission, just get on with it. But in terms of the advocacy issue, I think the playbook will be similar to The Voice, the negative story, the negative story, the negative story. And one good thing that the HRLC, the Human Rights Law Centre, has been doing is a lot of testing of messaging, etc. And they're very firm on the fact that we actually need to sell the positive story of the charter, not the negative story of the charter. So I know back in 2008, the Castan Centre did, myth busting. So we kind of put out there the negative story and answered it, whereas they were saying, actually, just don't even put out the negative, just put out the positive in what we're saying. So that's something we're going to have to really focus on. The other thought I had, and Kate, it can't be in your talk about this whole unelected judges making decisions that should be left to, the elected decision makers. I'm kind of hoping that trust in our elected decision makers is at an all-time low, and that this sort of argument won't gain as much traction in the next 12 months as it might have in other times. So they're just two random thoughts.
Thanks, Julie. Jessie, did you have anything to add?
Sure. Yeah, I do. I suppose I'm a little conflicted on this question as well, because it's always been my view that the best human rights come from the ground level up, that the best human rights acts come when there's a massive groundswell of public need or a call for those charters or rights. I think that's where you really see the best support and therefore the best protection. But I've been reminded that actually there are examples where that's not the case. So, for example, in the ACT, you can't really say there was a massive groundswell of support for a Human Rights Act. There were none of those sort of protests or the sort of hallmarks of what you might think of as that like public support. But actually, it's been very useful and quite powerful, and it hasn't led to any kind of a backlash. So I think that there are two sides to that story. I do think that education and having education as one of the pillars for human rights is really important, because, as John says, there's a lot of discussion about these same old issues that really just are water under the bridge. We need to move away from this sort of fixation on some of these issues that, that there's something really unique about the Australian Constitution that means we can't protect human rights. That's just not true. We really need to move on. It's been shown not to be true by so many careful scholarly expositions and so much work. So we really need to move past that. And I think education will be really, really key.
Thanks, Jessie. Kate, did you have something to add?
No, look, not really. I mean, I've made the point that lawyers have a very important role, obviously, in ensuring this law works, but lawyers are also often at the forefront of advocacy, and so we become a very easy target on the lawyers' picnic, etc. I do think the positive story is the way to persuade politicians that it makes a difference for their community. And I think, again, having done this work for the Royal Commission, the power of storytelling in human rights is very compelling. And I think hearing stories of where somebody's rights have been violated and they're able to achieve a successful remedy or outcome is really important. Some of to your point, Julie, I think sometimes the negative stories, which are about where there's gaps in the rights and the negative outcomes for people in not having rights protections, are also powerful stories. So it's a different way of sort of couching the negative as opposed to the sort of doomsday concerns that people often have. But I agree with you. I pulled out submissions I did for the New South Wales Bill of Rights in March 2000, and I felt like I could have just put today's date on it and used it again. So I agree with everybody. We need to move past these sort of cyclical objections and really be very person-centred and focused on the benefits.
Thank you, Kate. There's a question in the chat for you. We're very short on time, but I thought I might just get you to your views on it. It really goes to why not have criminal remedies for breaches of human rights that already exist in other laws. If you could maybe address that.
Okay, so it's quite a long
It
question.
is.
And so I thank the person for their question very much. But I think what it highlights is that the nature of human rights can be wide and diverse. So a remedy, if there's been a failure to accord a fair trial or a failure in a criminal law procedure, is a particular remedy that we need to think of, and it might be a very procedural remedy. But then there are other remedies, and the example given is the Disability Discrimination Act and the requirement of reasonable adjustments. That's quite a specific remedy to give effect to concepts of substantive equality. And so you might want to build in those remedies as well. So one part of it is to have a very flexible approach to ensure that the remedy adequately addresses the relevant right, and not just assume because there's one suite of rights altogether that the same remedy is going to be applicable for all those rights as well. So again, I think, as people have said today, having an exposure draft and really thinking about remedial pathways, so the procedural rights and also the substantive remedies, to be flexible or join them with other forms of proceedings. So Ros has talked about that today in terms of the piggyback approach, is also helpful to consider. So that I may not have done justice to the question, but I hope that helps.
I'd like to add, with bills of rights, the most important thing really to remember is very few cases are going to ever get to the courts. I mean, ideally, we don't want them to get to the courts. Now, I know I didn't ask any of us on the panel to talk about this, but I'm going to pipe up now. It really is incumbent on the executive and the parliament to start making laws in the first place and creating policy in the first place that's rights respecting. So there is a big piece of the puzzle of the Human Rights Commission report, my submission to the inquiry, etc., about how we get the executive and parliament to properly engage with rights in the first place and to make sure that their policy and their laws, you know, are consistent with rights in the first place. So I want people to remember that piece of the puzzle and to try and put as much pressure on our democratic systems of government to actually put rights front and centre, and not get to the point where lawyers are having a picnic and judges are, you know, making undemocratic decisions on people's rights. Thank you.
That's all we have time for, I'm afraid, and it was a very short Q&A session. I think we could probably very easily spend the rest of the afternoon discussing these issues. Thanks very much, everyone.